Hi, everyone. Welcome to our webinar today on estate planning for professional women. And so we are giving this to you from Chavis Law Firm today, where we are helping you to build legacies that you can trust. So this is a really important topic for all individuals, but because it is Women's History Month, we are going to do something a little special for professional women, because we want to make sure that you have all of your ducks in a row, that you are set up as you need it to be. Need to be with your estate planning. You have spent so much time building your legacy and building your businesses and building all the things for your loved ones and your family. So we want to make sure that you have exactly what it is that you need. All right, so here we go. So here are the takeaways from today. We want to make sure that you have a plan in place that is representing what your intentions are, because the state has a plan for you if you do not have your own plan in place. And I'm going to tell you, it is not the plan that you want. We are going to talk about why having just simple boilerplate documents are not going to get done for you what you expect them to get done. Just how if you're in business, that just grabbing a contract offline would not serve your business and your business unique needs. It is the exact same thing for your estate plan. Just because you find it on the internet and it has some legal words in it that look like, a will or trust or what have you, does not mean that that document is actually capturing what your intentions are for your estate, for your assets, for the legacy you're building, or for your family. We're also going to talk about what some of the next steps will be to make sure that your family, your business, whatever it might be, are well taken care of if anything should happen to you. So first, the basics. The first question is, do you have a plan? For those of you who answer yes, that's great. I'm glad. For those of you who answer no, well, here's the reality that there is a plan. It is called the Intestate Laws of Pennsylvania. And so there's a statute on the books for Pennsylvanians that talks about what happens to a person's stuff, to their estate, to their assets, if they die without a will or an estate plan in place. There's a statute that says what percentage of your estate will go to your heirs, spouse, parents, children, siblings, that type of thing. And so while there's a statute that is on the books outlining that, it may not really represent how you want your assets to be divided. So in its most basic form, here's a definition we're going to use for estate planning. Estate planning is the process of making sure your family, team, or clients aren't left with a mess if something happens to you. A lot of people are intimidated by the word estate planning. They don't want to put something in place because they think, well, that's just for rich people. I don't have anything to put into an estate plan. That's not true. If you have stuff, you have something to put into an estate plan. If you have a house, car, if you have money in the bank account, those are things that you have to have a plan for. Otherwise, the intestate laws that I just spoke about will take care of or will dictate the way in which your assets will be distributed amongst certain people. I hear horrible stories all the time of people who have loved ones who died without a will. And I can tell you from personal experience, sitting in my office here, meeting with people who are crying from the grief of losing a loved one, and at the same time have to deal with the court administration, the administration of the estate through the court process, and trying to figure out what their loved one's intentions were, or trying to get in touch with the bank and the bank won't talk to them, or just figuring out what does the process look like now that their loved one has passed away. And they're dealing so much with trying to undo the mess that was created because of a lack of a plan. They really don't have a chance to properly grieve. So we always say that estate planning isn't just for you, it's really for the people that you love. And it's such a great gift to give them, not only the fact of having your assets, your estate planned out, but you're giving them the gift of grief. And I know that sounds like it's contraindicated, that those two things shouldn't go together, a gift and grief. But grieving is a process that we all go through when we lose someone that we love. And if someone is forced to take care of a mess of the estate plan, they don't have the ability, time, or space to grieve and go through the process of losing the loved one, the person that they care about. So we don't want to rob people of that process. It's for their benefit to be able to go through grief. So we don't want them to be focused on administering estate and undoing a mess and not focusing on that. All right, so 5 basic documents are pretty much included, at least in the estate plans that I do for my clients. The first is a will. This is probably the item that most of us are most familiar with. It outlines a person's assets and their belongings and how they are supposed to be distributed after a person dies. A will only goes into effect when a person has passed away. In other words, if you list a beneficiary or beneficiaries in your will, they can't demand to get those things while you're still living. The will has no power to do anything until the person who made the will has passed away. It can also name the guardian of minor children and may include instructions on funeral arrangements. And so for some people, that's really important, that they want a burial versus cremation or vice versa. Or I had a client who wanted to have a green funeral, something that was environmentally friendly or would not have an adverse impact on the environment. So those are types of things that you put within a will. Now, not only does a will list out your assets, the will, for it to be processed, if you will, has to go through probate. That's the court process. It is an open process, meaning that I can any person who have had a will filed after they passed away or their estate had it filed, I can actually go online and find the will because it's completely public. It is costly because it is a court process. You have to pay the court fees. There are certain filings of documents that have to occur. It's a long checklist of items that have to go through or that have to be completed to go through the probate process. But that is the means by which the executor or the personal representative is appointed to the case or accepted by the court to then administer the estate. And then the will as written is then accepted by the court. Now, some people want some added protection, or they want the ability to avoid passing their assets to loved ones without going through the probate process. And the means to do that, at least in Pennsylvania, is by setting up a trust. There are 2 types of trust. You can have either revocable, and that's the kind where you change your mind. You get to revoke it. You get to undo what you did. You can put assets into the trust. You can take it out. For the other type is irrevocable. And just as the name indicates, pretty much once you have it set up and you put assets in there, there are very limited means or limited ways in which you can undo it. So you have to be very clear about what you want to do when you're setting up an irrevocable trust. But generally speaking, a trust is when you have an individual, a trustor, the grantor, the trust maker, will transfer assets to a trustee. And that trustee is the person who manages and distributes those assets to the beneficiaries according to the terms of the trust. It can help to avoid probate, as I mentioned, and provide even more control with how the assets are distributed. So, for example, under a will, it may say that you are giving all of your money to your children, when they reach the age of majority, and the money is just given outright as they are beneficiaries of the will. But a trust may say, I want them to get a portion, like a third or what have you, or 50% of what is owed to them under the terms of the trust when they each reach age 21. Then they'll get another portion at age 25 and the balance at age 30. Just because you have concerns about giving your children, a high figure, a high amount of money before they really are able to mature and are able to manage those funds. So that's something to consider with the trust. So for both the will and the trust, essentially the way in which they work or operate, they come into effect, generally speaking, when a person passes away, or it was specifically when a person passes away. But there are instances where decisions have to be made for an individual who cannot make decisions for him or herself. That is in the issue of incapacitation. And when a person becomes incapacitated, whether it's through illness or maybe a car accident where they're in a coma, what have you, they are not able to effectively or competently state how they wish to have their medical or financial affairs managed, then a power of attorney is the document that gives power to another person to make those decisions on that person's behalf. So the person who's making the power of attorney is called the principal, and they appoint another person, the agent, to make those important decisions on their behalf. A power of attorney is only effective when the person is alive and incapacitated. I've had clients say, they have a loved one who died. I'm like, oh, it's okay. It's okay. I got the power of attorney. Well, it's great that you have a power of attorney, but that does nothing to manage the person's estate if the person has passed away. And the only document that you have is a power of attorney. So you might think, well, what type of decisions will be made? So let's say if it is hiring a home health care person and speaking to the home health care agency and speaking to the insurance company, if you're incapacitated, you're not able to make those calls and decisions on your own, the power of attorney would then have the power to do so. If it is financial matters, such as a person who's incapacitated has a home that has a mortgage and the bank and the payments come out of a bank account, the power of attorney is able to talk to the bank about continuing payments to the mortgage company. The mortgage company will accept the payments, and they're speaking to the power of attorney to make sure that these decisions and topics are being discussed while you are incapacitated. The fourth basic document is a healthcare directive. It includes that healthcare power of attorney that we talked about. It also would include a HIPAA authorization, allowing the power of attorney to talk to medical professionals where otherwise those conversations would be protected and confidential. And then also it gives directives if the person who's making the document ever gets to an end stage medical condition where they cannot make, where they will never come back no matter what treatment is given. So it is a directive saying, I do not wish to be resuscitated, or I do not wish my life to be sustained on a ventilator or any other mechanical or electronic means, those type of things. It says, I just want to be kept comfortable. I want to be have pain managed, that type of thing. Those are specific healthcare directives. If there ever was a time that an individual who makes a document would come to end stage, that is the key thing, end stage medical condition. And fifthly, the Kid Protection Program. And so this is for people who have minor or special needs children, and they start to contemplate, well, what will happen what will happen to my children if something happens to me? Who will watch over them, whether it's for short-term or long-term? I offer this. It's on my website. You can go to chavislawfirm.com. There's a link there to a free Kids Protection Program. Kids Protection Plan that allows you to nominate the persons that you would want to watch your children, either again, short-term or long-term care, to prevent them going into care until the court would then decide who would care for your children. It outlines people that you believe would be great in caring for them, whether it's short-term until the long-term caregiver can be determined. Sometimes in most situations, it's the same person, but let's just say if it isn't, you can name that long-term person, a long-term care person, and it also will allow you to name individuals that you do not want your children to go into the care of. And then you know your family, you know the situation. There might be someone that you do not ever want your children to be in their care. So that's the purpose of the Kids Protection Program, to allow you to nominate those individuals, and that way your plan regarding your children, your minor or special needs children, is very clear. So what happens without planning? So if there is no plan, whether it's a will or there's no power of attorney, in case you're incapacitated, that means your family would have to go to court to have access to your bank accounts and pay your bills. People have this myth. They say, well, I'm married, so of course my spouse will be able to have all those type of discussions. Well, if you're the sole name on the mortgage or on a bank account, or is the example of medical needs, those professionals are not going to talk to your spouse just because the person is your spouse. Or if you have children over the age of 18 and you say, well, I'm the mom, that's great. But they are still not going to release information or have discussions with you simply because of your title. It is the legal documents that you have in place. And if they're not in place, you will have to go to court. Again, bring up the issue of people being sort of scared to have discussions with attorneys about estate planning because they think it's going to be so expensive. I guarantee you this, the cost of getting the documents in place are a fraction of the cost of having to go to court to be appointed a guardian or to have to figure out what the estate is and have it administered. So just food for thought. So what else could happen? You could have the wrong people making decisions about your money. You have decisions that could be made that are not in alignment with your intentions. And if you die without the will, then you're going to be subject to the state's intestate laws. So you could have your parents responsible for administering your estate. And if your parents aren't available, then you have siblings to do so. So it really, the statute then outlined the individuals who would then be eligible to administer the estate, in addition to the persons who would then be the beneficiaries of your estate. If you have no living family, or if none of your family will qualify to administer the estate because they can't post the bond to do so, and that would be required if there's no will in place saying otherwise, then the court will then appoint a financial guardian, which of course can be pricey and can end up dissipating the assets of the estate. If you have minor children at home, that is certainly a hard discussion, because if there's no plan, is it a possibility of your child going into the care of someone that you really had no intention of, or going into the system until a more permanent resource is identified? So if you have not done so, what legal authority is there in place for the care of your children? And have you named a guardian? And then also, where are they located? And is the fact that that's the individual that you want to be the guardian of your children or your child, does anyone else know that? How has that information been conveyed? So what about when you have young adult children? You certainly, if they're over 18, you want to make sure that you have the powers of attorney in place. And again, like I said, if you don't have it, then you're not going to be able to have discussions with their banks. So let's say if you have a college-age child, or a child who is graduated from college or in workforce, and they have a bank account, they have an apartment or a home. If there is no power of attorney in place, those entities are not going to have discussions with you or any other person without proof of either their incapacitation or that they have passed away, God forbid. So that's why it's important to have all of these documents in place for any person over the age of 18. That is not a time where you want to have to undo a mess like that when you're under the stress of something happening to your child. Your parents. Oftentimes I'll have clients who come in who are 30, 40, 50 years old, and they're going through this process, and they're really relieved and happy to have this issue sorted out for themselves. And they realize that their aging parents do not have it in place. Just this week, I've had numerous phone calls about individuals who need to get something in place for their aging parents, and several of them do no longer have the capacity to create their own documents. In other words, they have dementia or some other type of condition where they can no longer make the decision. And now we have to go to court to begin the process of having guardianship appointed because their parents have just reached the point where they are no longer, would the documents be considered legally valid. So this is certainly a discussion to have with your parents about making sure that their affairs are in order. And if so, where are those documents? Where are the documents? Are they all in one place organized so that whomever has to step in as the administrator, the executor of the estate, knows where to find the documents? Or if someone needs to be a power of attorney, do you know where to find those documents? So you don't want to rely upon, the online legal forms that are super cheap, or going to an attorney who's going to do it for just, a couple $100. You need to determine, is this an attorney who actually knows what they are doing? Because just because you're hiring an attorney doesn't mean that individual knows how to craft the estate plan that matches and aligns with your intentions, with how you want your assets to be distributed and how you want your estate plan to be set up. Again, this is not something that you're doing solely for yourself. It's something that you're also doing for your loved ones. Just how you have put time and effort and investment into your career and your professional life and your business. This is not a place where you want to say, I'm going to scrimp and save, or scrimp and scrape and just for a couple pennies get it in place. Put in the same effort of professionalism and to make sure it is just as solid as every other area in your life to make sure that your intentions are captured. You want to make sure you're working with an attorney who is helping you to make the educated choices for yourself and your loved ones. Flat fee packaging. You don't want to feel like I'm going to be charged for every phone call or every email. You want to find someone who's going to give you a package or a plan that's flat rate to give you the documents and the plan that you need to execute your intentions. You want to work with an attorney who gives regular updates to your plan. Just as your life changes, as your business grows, you're buying property, you want to make sure your plan grows and changes along with you. helping you to organize. The attorney can help you do that with family wealth inventory so that no assets are lost or slip through the crack, making sure that they're providing you the ability to capture the intangible aspects of your assets, your life and legacy interviews. What would you want your loved ones to remember? For my clients, I record it. I'm actually able to tell them, hey, let's do an interview. We'll record it and put it with your documents so that your family can look back and reflect on hearing you speak about your values and the things that are important to you. And of course, the kids protection plan, as we were talking about earlier. So what are your next steps? So after you've watched this webinar, you should be able to download proof that you have watched it. Call us, email us, go to our website, connect with us to schedule your life and legacy planning so that we can make sure that you are on the road to securing the estate plan that reflects your intentions and that it actually captures the legacy that you are building and that you're working so hard to do. We will make sure that you can have this meeting with us for free. There's no charge. You show proof that you attended this webinar, and we will help you to gain peace of mind and clarity and assurance that you and your family can be cared for through this estate plan, both now and in the future. So we thank you for joining us. Here's all of our contact information. We hope that you found this information to be useful. As a woman who is a professional, we know that this information is important to you. So just as you handle your business and every other area of your life, we want to make sure that you complete it in this area as well to make sure you have a solid estate plan for you and for your loved ones. All right. So with that, thank you so much for joining us. We hope to hear from you soon or connect with us on Instagram at Jenny Chavis ESQ, and hope you found this helpful. Bye-bye now.